Hello everybody, Martin Radner here from Radner Law Group, bringing you trial analysis, and today we're going to be discussing the Eric Bland interview, which is associated with the Alex Murdaugh allegations that there was jury tampering. Who is Eric Bland and what is his interview and whether does it make a difference or not? We will jump into that in just 1 minute, but before we do, please like and subscribe to this channel so we can continue having this channel grow, so we can continue bringing you this trial analysis. So, who is Eric Bland and what's he doing giving an interview about this case? Well, Eric Bland is a partner at Bland and Richter LLP. That's a firm based in South Carolina, which, as you all know, that's where the Alex Murdaugh trial occurred, and that's where ultimately the guilty verdict came down. So he specializes apparently in legal malpractice, medical malpractice, and catastrophic accidents. So seems like a personal injury attorney, and he has been very open about this trial, about what his feelings about this trial is, and he is certainly a proponent of a guilty verdict, and he certainly believes that Alex Murdaugh should be sitting and rotting in prison. So he put out a Twitter post, and this is how this all started. So he put a post on Twitter, and this is what it says. At the press conference earlier this week, referring to the press conference that Dick Harpatulian put on, where he let everybody know that he's filing this motion for a new trial based on some affidavits which lay out allegations from the jurors that there was some serious jury tampering occurred, and I had made a video about that. You can take a look at that video that I made. So at this press conference earlier this week, Dick Harpatulian suggested that the jurors should get lawyers. How offensive is that? How threatening is that? Obviously, Ms. Hill had to get lawyers and pay for them. If any juror feels like they need legal representation or just to get some advice, please feel free to call Ronnie Richter, which is his partner, and me. We would not charge a fee for the consultation or representation. It's just disgraceful. The people are having to pay for legal fees in this most unfortunate situation. So Eric Bland making a plea to the jurors, please contact me. I'm not going to charge you for the representation. I'm not going to charge you for the consultation. It's going to be 100% free. Seems like such a great guy. But, I'm sure he is a great guy, but I'm just letting you know, everybody knows that when you take on a case like this, you're going to be getting so much publicity that you can't pay enough for that type of publicity. So at the end of the day, he's going to be getting his publicity. He's doing these interviews, and, his firm is probably going to benefit even if he does not actually get a dollar amount from these jurors that eventually contacted him. So he did get 2 jurors to contact him, and now he is representing these 2 jurors. So what else do we have to know about Eric Bland? Well, during his interview, he says that he is very victim-oriented and pro-prosecution, and he makes this very obvious. Take a look.
How did this come about? Was it because you put your tweet out that they reached out to you?
A little bit, but I've been victim oriented throughout this whole ordeal for the last 2 years, pro-victim and pro-prosecution.
So that's just to understand, who we're dealing with and what his feelings and what his views are in this case. Then he continues to say that he really has no problem with the motion that was filed in this case for a new trial. I mean, after all, attorneys can file motions for new trials. It happens all the time. And in this case, certainly they felt that they had a basis to file a motion for a new trial. And that's fine. He has no problem with that. He has no problem with them speaking to the jurors. That's also 100% legal. You're allowed to talk to jurors after they are no longer hearing the case. So there's nothing wrong with that either. He has no problem with that. So what does he take issue with? So the first thing that he takes issue with is that he feels that press conference, Dick Harpatulian violated the rules of professional conduct.
I did take umbrage with how he handled the press conference and what he said, because I don't think it comported with our pretrial publicity rules that we have with the rules of professional conduct, with some of the things that he said. It was designed to really sway and move the public. It wasn't in response to anything that the Attorney General had filed or said. And it was meant to be explosive, which is exactly what he accomplished.
So taking a look at the rules of professional conduct, every single jurisdiction has their own rules of professional conduct. A lot of them are actually very similar to each other, and a lot of them are very similar to the ABA rules of professional conduct. So this is Rule 3.6. I took this from the South Carolina Rules of Professional Conduct, which deals with trial publicity. So, of course, the rules span a whole bunch of different rules. This is where the basis where attorneys get reprimanded and disbarred. But here is a rule. It's called 3.6, trial publicity. And this discusses how an attorney, or what type of information an attorney is allowed to share with the public. So in 3.6a, this is what it says. A lawyer who's participating or has participated in the investigation or litigation of a matter So certainly Dick Carpatullian would fit into that category. Shall not make an extrajudicial statement, shall not make a statement basically out of court, that the lawyer knows or reasonably should know will be disseminated by means of public communication, meaning that he knows that everyone's going to hear about his comment, meaning a press conference. So he should not make this communication if he knows or reasonably should know that it's going to be disseminated to the public and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. If it will have a substantial likelihood that that comment or that press conference is going to be materially prejudicing, meaning it's going to affect an adjudicative proceeding, meaning a proceeding in front of the court. So that's an adjudicative proceeding. So if you feel that your comments that you're making out of court are going to affect a proceeding in court, you're not allowed to make that comment. But without getting into the weeds of that, which generally sounds like, okay, you're not allowed to talk to the press at all because it may have an effect or whatever. It could have substantial likelihood of having an effect on an adjudicative proceeding. In B, this is what it says. Notwithstanding paragraph A lawyer may state, and here's B1, the claim, offense, or defense involved, and, except when prohibited by law, the identity of the persons involved. So clearly, in B1, you are allowed to talk about the claim that is being made, and you're allowed to talk about the identity of the people involved. So here, what did he do during the press conference, really? All he did was he identified that it was the court clerk, and he talked about the claim that is being made and the support for the claim that is being made, which is the affidavits that were signed by the jurors. So, of course, it is explosive, but there's nothing in this rule that says you're not allowed to make an explosive comment. You are allowed to talk about the claim. So if the claim is explosive, well, that's okay, according to these rules. So, again, my reading of this rule does not seem that Dick Carpatullian violated this rule of professional conduct. I think that's just trying to push too much against him by Eric Bland. Now, something that he mentions also in his interview is that, well, it wasn't in response to anything the Attorney General filed or said. Now, what's he saying that for? What it's in response to what he said? Where does it say anything about a response to what he said? So if you look, actually, in this rule of professional conduct 3.6, in the comments in 7, this is what it says. It says, finally, extrajudicial statements that might otherwise raise a question under the rule, meaning comments that may raise questions about whether you were allowed to make those comments. Essentially, I'm not going to read it for you, but basically what it says is that if it's in response to what another party said that you feel is going to prejudice your client, you are then allowed to make that comment. So even a comment that may not technically be permitted under these rules, but if it's in response to a comment that was made by the other party, then you would be permitted to make that comment. So that really has nothing to do with this case. The question is whether the statements that he made at the press conference, are they within these rules or not? And it seems from my reading of the rules that they're certainly within the rules of professional conduct, and I don't think that Dick Carpatullian violated the rules of professional conduct. And just as a side comment here, attorneys, we're hired to fight. That's basically what we do. We fight all day. We fight with each other. Now, of course, we're cordial with each other, and outside of the courtroom we can be friends. But in the courtroom, we're essentially hired to fight with each other, and we fight, using legal analysis and using, the facts to our benefit, and that's what we're all trained to do. But the minute that becomes personal, no attorney appreciates that. So we can fight all day, and I can say that your legal analysis is trash, and you can say that my legal analysis is trash, and I can say that you're misrepresenting the facts, and I can say that you can say that I'm misrepresenting the facts. That's what we do all day. But the minute that you say you're not following the rules of professional conduct, there's a problem with your ethical values, or there's a problem with your morals, then it's becoming personal. Then it's becoming personal, and you really kind of crossed a certain line there. And it just seems like, it's not like he said anything that's just obviously violates these rules. So I understand that, Eric Bland, he's very pro-victim, he's pro-prosecution, he wants Alex Murdaugh to be thrown away, and die in prison. That's fine. Everyone has the right to their opinion. But when you're making it personal and you're saying, well, he violated the rules of professional conduct, I think that's just taking an extra stab that really he didn't. It's not necessary in this situation. Okay, so let's move on to some of the other issues that he has. So this is the next issue that he has, and he has an issue with Dick Carpatullian's reference about Judge Newman being able to hear this motion.
What I didn't like is the threats that he put in his press conference. One against Judge Newman, saying he was going to be a witness, wouldn't be able to hear the motion if it was remanded by the state appellate court.
So he says that he threatened that Judge Newman won't be able to hear the motion. Now, here is the clip, and you can tell me whether you feel that this is a threat.
There's no suggestion that the judge did anything untoward. But what that does do, if it comes back, he may end up being a witness.
So he said he did nothing wrong. He might be a witness, and therefore he might not be allowed to, to hear the motion. That's what he said. And that doesn't sound like a threat to me. In the way that Eric Bland sounded like he was threatening him that he can't hear. I mean, that wasn't a threat. He was just saying, it could be that he's a witness now, and a witness will not be able to hear this motion. So, it's just a real concern. It's just something that may be a concern coming down the, if this all comes down the right way, and according to in Dick Harbertullian's world, if this comes down the right way and we have to hear this motion, he may not be able to hear it because he's now considered a witness. So I don't think that that's a threat. Again, it's just kind of his, Eric Bland's feelings coming out that he's just trying to paint everything much worse than it is. Okay, let's look at the next issue that he has with Harbertullian.
One, I don't like when jurors make a decision and are individually polled and then say that the verdict was the product of their own free will. It was a just verdict and there was no coercion. And each individual juror at that case was polled. I don't like it 3 months later where somebody can come back and start to change jurors' minds. That's a dangerous thing for our system.
So, interesting point. So he doesn't like that the jury is polled, and this is what happens after almost every trial. The judge asks, the attorneys, would you like me to poll the jury? And usually the winning party says, no, that's not necessary. And the losing party says, yes, they do want the jury polled. And he goes through each individual juror and he asks them, the juror, or he asks the clerk, or the clerk asks them, is this your verdict? Was this your verdict? There's different ways that you can ask them, but basically you're asking each juror, is this your verdict? And the juror answers yes. So now, says Eric Bland, well now, 3 months later, someone's going to come and say that they changed their minds. And that's a very dangerous thing for our system, to have it where the jury decided a verdict and now 3 months later they're going to say, well, we changed our minds. Now, of course, I think everyone can agree that the jury had one time to deliberate. This is your time. And if you change your mind tomorrow, no, that's too bad. I mean, I think everybody would agree with that. But that's not what happened here. That's not what happened here. That's not the suggestion of what happened here. The jurors are not coming back and saying, we want to look at the evidence again and we think that we're changing our mind. That's not what's happening. What's happening here is that the jurors are saying that the process was tainted, is that there was some jury tampering here, that the clerk was making comments to them which are inappropriate. And it could have changed their whole mindset of the case. So I think everybody would agree that we want a fair process. Everybody would agree that no matter how bad you are, you deserve due process. I mean, that's a fundamental right that we need to give every single person, no matter how evil and terrible they are in our society. Every single person is entitled to due process. And the minute that we take away that due process from somebody that we feel doesn't deserve it, it's a very, very slippery slope. So we don't want to do that. Everyone deserves due process. And if a juror comes back later, after 3 months, and says, the clerk was whispering in my ear the entire trial, well, of course, everyone's going to agree. And I want to live in a society where we could reopen that case and say, no, this was not done fair, and therefore we have to redo it again. And I don't care if it's 3 months after the trial. I don't care if it's 3 years after the trial. If it comes to light later on, and this happens, by the way, years and years and years later, it happens that something was wrong with the process, terribly wrong with the process, and people will get freed from prison that they were sitting in prison for years, which was unjustified. So yes, I do want a system where we're forced to make sure that that the process is fair. And therefore, in this situation, if this really actually happened, then yes, we should go back, reopen the file, and try the case again if necessary, to make sure that it's fair and everybody gets their day in court and that everybody has their due process. So again, the way that he was presenting this, that, the juries just changed their minds and it's not fair to have such a system like that, that's not what happened here. And let's just be honest here. Okay, now, the interview asking, well, why did you get involved? What are the reasons that you got involved?
But the most important reason why I got involved was because Dick said that the jurors needed to lawyer up. And it was an extraordinary thing for a lawyer to say, why would jurors need a lawyer? And so that was really the genesis of why I made that offer.
So this comes back to really his Twitter statement. And again, we'll just read the beginning here. He says, at the press conference earlier this week, Dick Harper-Tullian suggested that the jurors should get lawyers. How offensive is that? How threatening is that? So, you know, I don't think that's threatening, and I don't think that's offensive. I think everybody understands that this is a very big case, that you have a person that's sitting in prison now, is going to be sitting in prison for the rest of their lives, and now there's a question of jury tampering, which you never hear of, very, very serious allegations, and now these jurors are going to take the stand, most likely, in an evidentiary hearing, and the media is going to be all over them. Are you saying that, is Eric Bland suggesting that they don't need attorneys? Of course they need attorneys. You need attorneys to deal with the press. You need attorneys to tell you what to say, what not to say. Most of the time they're going to tell you, just don't say anything. Don't say anything until we're actually in court, and prepare them for the evidentiary hearing, prepare them how to answer questions under oath. Of course you need a lawyer. So I don't know what the suggestion here that he's making is that, oh, that Dick Harper-Tullian was just scaring everybody and threatening them, and it's offensive to say that they need lawyers. No, I think it's a fair, it's a good piece of advice that they should get lawyers. You know, the jurors should get lawyers because they're all going to be, you know, questioned under oath, and who doesn't want a lawyer when you're being questioned under oath? So, again, it's something that I don't really buy into, his whole tone and his whole demeanor here, that he's just trying to attack everything that Dick Harper-Tullian did and said in that press conference. So, what are the jurors going to say? What are the jurors going to say? So that was the question that he was asked, and this was his answer.
But I can tell you this, Anjanette, that I believe when they go under oath, they are going to not support the allegations that Dick Harper-Tullian raised in his motion and in his press conference.
So I think one thing that's clear to me is that he's not representing the jurors that signed those affidavits. He's probably representing jurors that agreed with the guilty verdict, and they think that Alex Murdaugh should spend the rest of his life in prison, and they don't want to see their verdict overturned, and they don't want to see him given a new trial. They feel that their verdict was good and it was fair, and that's what they believe in, and that's probably why they also got Eric Bland to represent them, because they're all in the same camp. But it doesn't seem to me that he's representing any of the jurors that that signed those affidavits. And because if he is, that would be just a heyday for the defense on once they get on the stand and they contradict what they wrote in their affidavit. So certainly I would be very, very surprised if he's representing any of those jurors who filed those affidavits. So it seems we're going to have jurors on both sides of the fence here. You know, some jurors are going to say, no, everything was fine, Becky Hill didn't say anything, or I didn't hear anything that Becky Hill said, or she didn't say anything to me specifically. And you're going to have other jurors who are going to probably testify consistent with what they put in their affidavits, that there was some communication with Becky Hill. You would imagine that that is what they would testify. They would testify consistent with what they put in their affidavits. And it does not seem, again, that Eric Bland is representing those jurors. Okay, and finally what he makes a mention of, and here is kind of like where he's kind of taking the role of prosecution here, which maybe he wished he was in this case, that, well, they weren't coerced. No one said that they were coerced to this verdict, and nobody said that it even factored into their verdict. Take a look.
I haven't heard any jurors say that they were coerced. I haven't heard any jurors say that what they heard, if they heard anything from Miss Becky, that it swayed them to change their vote or factored in any manner in their vote.
But the truth is that really, that doesn't matter. It doesn't matter whether they're coerced or not, because that's not the standard. You have to look at the legal standard. What's the legal standard for a new trial? The legal standard is not that the jurors have to say, well, I was coerced, I felt like there was a gun to my head, and that's why I voted guilty. That's not the standard. I mean, you just made up that standard. And it's really not even whether it factored into their vote. Now that maybe is a little more gray, but the standard is, and this is just taken from the law in South Carolina, the standard is, which is in a case, which is an opinion, was that if there's private communication between a court official and a juror, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless. If it clearly appears that the subject matter of the communication was harmless, which means what goes into that category? Do you want water? Do you want a bathroom break? Do you want a smoke break? Do you want to go call it a day? Do you want to talk to the judge? Do you just very, very simple questions. But certainly comments that are alleged that were made about believing whether you should believe the defense, whether you should believe Alex Murdaugh, whether there's discussions about, if the gun was important, that they found the gun or not found the gun. Some of the things that were alleged in those affidavits, certainly that was harmful. That was not harmless. So as long as the subject matter of the communication was harmful, then that's it. You need a new trial, according to this case. and that's the South Carolina case. So, this is what it seems like the standard is. It's not whether they were coerced. It's not whether they even it factored into their vote. It was just whether the communication itself was of a subject matter that was not clearly harmless. So certainly what the allegations in the affidavit satisfy that. So again, we will see what happens with the evidentiary hearing. We'll see under cross-examination, and then we'll ultimately see whether a new trial is granted. Okay, well, thank you. That's it for today. Please, again, like and subscribe to the channel so we will be able to continue bringing you this trial analysis.